Good morning. Are you Anthony Mendoza?
Yes, ma'am.
And Mr. Mendoza was previously in court and entered pleas of true to counts 1 through 13 in a motion to revoke probation. Currently on probation for driving while intoxicated, third or more. That was a 6-year sentence that was probated for 6 years.
Okay, quick legal breakdown. He was already on probation for a DWI with a 6-year suspended sentence. Translation: if he slips up even once, that suspended time turns into real prison time. Spoiler alert, he messed up. A lot.
I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, we have.
Are there any additions or corrections to that report?
No, Your Honor.
Not from the state judge.
All right, Mr. Parker, you may proceed.
Well, a couple of things I want to address. It's a situation I see quite a bit where he's ordered to have to scram and interlock. It's costing him $600 a month, and he's having to go to work, but yet he's not supposed to drive, and so he's driving with an invalid license, and he's not able to work, and he can't afford to pay for the things he needs to do, such as the 12-step program, the GED program. All those things require money, and that's one of the big issues. But the things I'm concerned about is that it says that he went to the safety relapse program. I'm not sure exactly what happened, but he says he never went to the safety relapse program. I don't know if he was ordered to go and he didn't go, but I think he was in custody at the time, and I'm not sure how that happened. But he also says he's never tested positive for cocaine, which is alleged in here. It addresses an issue that he apparently had with one of the directors of the facility where he became combative. And this also, in turn, is tied to a scram device. He ended up developing a big sore on his ankle, so he would put his sock behind the scram device. And in this incident, he was frustrated, and he wanted to take his boot off to show the director the problem that he had. And that's when they were saying that he was being disruptive. He has no other felonies, Judge, and he wants the opportunity to go back to he wants to complete his probation. He wants to do the safety relapse. I'd like to hear what they say of what happened with that, but I'm sure there's an explanation. And I think you'd also like to address the court, Judge.
Well, let me first make sure I've got the timeline, because it appears that I see that safety he completed and then was placed on zero tolerance in the high-medium caseload. And after that, there was an issue where he was testing positive, again, for alcohol and cocaine, which I understand he denies the cocaine, but that's what this alleges. And in October of 2022,
Let's recap. He's skipping mandatory programs, ignoring court orders, and somehow still denying drug use. But here's the kicker. He's not even in custody. How does that make sense?
assuming through an administrative hearing, was granted relapse safety.
Yes, ma'am. There was a motion to revoke that was filed and came before the court, and he was ordered to go to relapse safety, and he absconded, and he never went to relapse.
So he wasn't in custody?
No.
Okay. And then, so we didn't see him again until August 11th of 2023 when he was arrested in Houston. So here's the thing, whether you probably didn't get any paperwork. Come up here to the front in the middle here. From at least October of 2022 until August 11th of 2023, you wouldn't have known about anything because you quit going to probation. You were an absconder. And the only reason we found you is because you...
Plot twist. They couldn't find him. Not until Houston police picked him up for aggravated assault with a deadly weapon. Yeah, we're way past just missing AA meetings at this point.
You were arrested in Houston for aggravated assault with a deadly weapon. And then in May, we get you back here and you were sanctioned to 180 days in jail. So this is the third time, it looks like to me, that you would have been given an opportunity to remain on probation. I gave you upfront time, continue you on probation. Courtesy supervision was sent to Harris County. And then we have The scram device issues still alcohol violations, interlock violations, aggressive behavior, ongoing alcohol use. So if you didn't do the relapse safety, it's not anyone's fault other than your own, because if you didn't know about it, it's because you weren't going to probation. Mr. Nichols?
Judge, I think it's pretty clear. He was put on zero tolerance a couple of years ago, and here we are on the second time.
Third.
Multiple times.
Yeah.
And I don't know what else we could do. So obviously, I agree with the probation department's recommendation for revocation. I think he's had more than enough chances, Judge. In fact, there's just one thing I want to make the court aware of. If I can call Ms. Martinez real quick.
Yeah, sure. Ms. Martinez, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Go ahead.
Ms. Martinez, you were supervising, Ms. Mendoza was on Harris County supervision, correct? And you were back in October when he started having these violations and the warrant was issued. Did you advise him to turn himself?
So probation reaches out and says, "Turn yourself in." His response? A literal, "huh," in an email. Bro. The man's got the confidence of a Marvel villain.
Yes.
And what was his response to you?
He had responded with an email that said, "Ha."
That was his only reply to you. Did I ask you to print me out a copy of that?
Yes.
Showing you what Mark Stakes Exhibit 1, for purposes of this hearing, is this a copy of the email with his reply to you?
Yes.
I'll tender to the defense attorney, Your Honor. I'll tender to the court for purposes of this hearing. I'll offer Stakes Exhibit 1.
It's admitted.
And is that pretty consistent with his level of cooperation and attempts to probation while he's been supervised?
Yes.
No other questions, Your Honor.
All right, any questions?
Just a couple. I want to clarify on the relapse program. You said y'all came to court on motion to revoke. Is that my understanding?
Yes.
And so the safety relapse was ordered by Judge West.
Yes.
And he was here. The defendant was here. Mr. Mendoza was here at that time.
Yes, sir.
Well, wouldn't he have been taken into custody?
Let me make sure, because I wasn't supervising.
Okay.
It looks like the hearing was completed over the phone. He was not here. It was over the phone with the supervisor at that time. Due to him residing in Houston, he reported he had a lack of transportation to report back to the hearing at that time because he had tested positive for alcohol and cocaine. The supervisor had recommended complete relapse safety and issue a warrant for his arrest. So he was made aware at that time that he was going to have a warrant and we were requesting relapse safety.
I have no further questions of her, Judge.
All right, anything
I have
else?
no other questions for Ms. Martinez,
Your Honor.
Your Honor.
Thank you, Ms. Martinez.
I think he wanted to address the court, but we never did because
Sure.
we talked with her.
Go ahead.
Would you like to tell the court? Do you want to tell the court?
You're saying I went to safety twice. I never went.
Nobody's saying you went to Safe twice. We're saying you went to
You're saying
Safe
I'm
Hold on,
absconding?
don't, listen. I'm going to let you talk, but don't talk over me. We're saying that you went to Safe and then that you were ordered to go to the Safe relapse, but you never came and turned yourself in after that phone call where you were told that there was to be a warrant for your arrest. So no, you never went to Safe relapse.
And this is where it all unravels. He finally admits to ignoring court orders, but blames everything else. The system, the monitoring device,
the job.
everyone but himself. Classic, it's not me, it's the universe defense.